Members, good afternoon. Welcome to today's special meeting. We have a quorum. It's the appointed time. I call the meeting to order. Item number 1. Follow-up of the Court of Final Appeals judgment in the judicial review case Sham v. Secretary of Justice, FACV 14 of 2022. I now ask the administration to come in to join us. Members, if you would like to speak, please press the request to speak button. I'll read out the members' names and also tell you how much time you'll have each.
I'll
read out the names of members who have pressed the buttons. The first one is Ms. Carmen Kan, Mr. Eric Im, Mr. Holden Chow, Mr. Stanley Ng, Mr. Kingsley Wong, Dr. Tik Chi Yun, Ms. Maggie Chan, Ms. Starry Lee, and Mr. Lee Chung Kong. Secretary, ready when you are. Thank you. Members, Chairman, I thank Mr. Lai Tung Kwok, the chairperson, for convening today's meeting. This gives us an opportunity for us to report to you of our work in relation to the judicial review case, that is, Sham v. Secretary for Justice. This is in relation to the CFA's judgment. In relation to the proposal and the way forward, I have already set out the details in the paper. I am going to speak in detail in relation to the government's stance, the government's plan, as well as the proposed registration mechanism for same-sex partnership. In addition, I'll also set out the government's way forward. First of all, I'd like to reiterate that the government's long-standing stance is that under the Basic Law, it is firmly upheld that the monogamous and heterosexual marriage system is protected. So no matter what our policies are, this will not be different. And the judgment of the case clearly set out that under Basic Law 37 and Article 19, subparagraph 9 of the Bill of Rights Ordinance, that the constitutional freedom of marriage guaranteed and protected is confined to opposite sex marriage and does not extend to same-sex marriage. It is also the court's judgment that in relation to Article 10 of Bill of Rights Ordinance, that is, in relation to the basic rights, the government has the positive obligation to establish an alternative framework for legal recognition of same-sex relationship and to provide for appropriate rights and obligations. It is clearly stated in the judgment that under the alternative framework, it is not equivalent to marital relationships. The matters under the recognition, that is, in relation to the rights and obligations, the administration has discretion to decide on a number of matters. The CFA exercises its final power of final adjudication. The judgments are final, conclusive, and binding on all parties, including the government. We understand that in relation to same-sex partnership, there are different views. It's a controversial issue. However, we recognize that we have the positive obligation to establish an alternative framework to fulfill the requirements under Article 14 of the BLRO. This framework involves complex issues and wide-ranging implications. We have been conducting detailed research on developing the alternative work. We carry out detailed research on policy and legal aspects as well as practices in different jurisdictions. We have also drawn reference from the motion on the 12th of February, that is, in relation to upholding the monogamous and heterosexual marriage system in Hong Kong, as well as the suggestions. We work on the framework, striving to strike a balance. On one hand, we ensure that we meet the requirements of the court, and at the same time, we will uphold the traditional values, the marriage systems of Hong Kong. We also aim to put in place a mechanism under which there will not be abuse and there will not be any negative impact on our society. We aim to create something that will not cause division in society. In relation to registration, in relation to the conditions, 6 conditions will have to be met. First, the parties are of the same sex. Both parties have reached the age of 18. We think that the parties should be adult, to ensure that they are mature psychologically and they have the capacity to act and make a decision that is legal. Under the relevant legislation in Hong Kong, 18 is the age when someone is legally an adult. We've drawn reference from other jurisdictions. 18 years of age is the statutory age of civil union as well as a same-sex partnership. The third condition is that the parties are each, or a party is a Hong Kong resident. Information in relation to the relationship has to be provided. We want to ensure that this will not have a major impact on the traditional values of Hong Kong. The fourth condition is that the parties have registered a valid same-sex marriage, same-sex civil partnership or same-sex civil union in a place outside Hong Kong in accordance with the law of that place. We notice that there are media citing the words and comments of certain parties, including those of Mr. Sham. The views are of the effect that this condition will cause major difficulties and fail to meet the needs of same-sex partnerships in Hong Kong. I just quoted what was reported in the newspapers. So I would like to elaborate here. I would like to say more about the factors we have taken into consideration in relation to setting this condition. I must emphasize that this is in relation to the positive obligation of the administration to establish an alternative framework for legal recognition of same-sex relationship under Article 14 of BORO. The relationship is a committed and stable relationship. That is, for sure. A relationship that is not committed nor stable does not warrant recognition, let alone affording the parties obligations and rights. The government is in charge of the registration. We have the duty to ensure that relationship is committed and stable. That is the condition that has to be met before we give them legal recognition. The government, under the framework, has a flexible margin. We can have interviews with the parties or require the parties to provide information, say for example photos of their shared lives or evidence of a life shared between the parties. Where there is doubt, we can require provision of certain records, say for example record of movement. We will need the cooperation of the parties. To the parties, the verification process may be seen as an intrusion or interference to their private lives, something that is inconvenient. But we, law enforcement parties, do not have any choice. We have to fulfill our duties and perform our duties duly. Another form will be the one we propose. That is, to give recognition of valid same-sex partnership registered outside Hong Kong as legally recognized partnership in Hong Kong. This is feasible. This also reduces the inconvenience caused to the parties. But in relation to the so-called difficulties of having the relationship registered outside Hong Kong, currently there are over 30 jurisdictions that have an arrangement to register same-sex marriage or partnership. Some of them even allow online registration. We believe that to a reasonable man, this is no great difficulties. It boils down to a choice of which way is more convenient. We all have to consider very carefully. If the policy changes causing greater difficulties, it may not be the most ideal arrangement for the parties. My advice to those who have spoken publicly is that when they speak in public, please do so in a responsible way and in a fully considered manner. Unrealistic comments or comments that may cause adverse impacts is not ideal and may cause harm. Now I go back to the conditions. Condition 5. Each of the parties does not have a valid marriage, civil partnership, or civil union that is registered with a third party. That conforms with the moral requirements of society. It is also a foundation of a stable relationship. 6th, the relationship of the parties must not be within the prohibited kinship relationship. We have added this condition to avoid people who are related by blood to form a relationship. This is easily understood and will be accepted. We will set up a same-sex partnership marriage. A public officer appointed by the Secretary for Constitutional and Mainland Affairs will be the registrar. Parties who would like to make the registration may do so by appointment. They will have to supply relevant information to make sure that all the required conditions are met. They also have to attend the registry in person to meet the registrar and take an oath. If the registrar is satisfied that all conditions are met, a same-sex registration certificate will be issued. This certificate will be accepted as legal evidence of the same-sex relationship. However, if there is any illegal conduct being discovered, say for example, submitting forged documents or making false statements, the registry will refer these cases to law enforcement agencies. The CFA also require, in addition to legal recognition, require the government to put in place the rights and obligations of same-sex partnerships. In this regard, the government also has flexibility. After thorough consideration, we've decided that the 4 categories of basic rights will be afforded. First, registering same-sex partnerships. Same-sex partners who meet the registration conditions can register their same-sex partnerships and obtain legal recognition under the alternative framework. 2. Revoking same-sex partnership registration. This is in relation to same-sex couples who have successfully registered their partnership with the registry. They have the right, under certain conditions, apply to revoke the registration. 3. Handling medical-related matters for same-sex partners. That includes visits in hospitals, obtaining medical information, participating in medical decisions. And when a party to the relationship is in a life-threatening situation, the personal data can be exempted from the restrictions of data protection principles under the Personal Data Privacy Ordinance. And also organ transplant between the parties is allowed. 4. Handling after-death arrangements. That includes identification of body at a public mortuary, claiming the body and making arrangements for the funeral, using cemeteries, crematoria, and columbaria under the Food and Environmental Hygiene Department, as well as deciding whether to have the body of the deceased partner to be used for therapeutic purpose or for medical education or research purposes. The government has a positive obligation to establish an alternative framework for legal recognition. By that, the meaning is that there will be official recognition and protection afforded. The government, as a result, will legislate to establish the framework. We will submit the registration of same-sex partnership bill to the LegCo for scrutiny. This is to establish the registration mechanism under the alternative framework. That's the end of my presentation. In addition to myself, as well as my colleagues in the CMAB, there are also representatives from the Department of Justice. We'll be happy to listen to members' views and answer questions.
In total, 11 members have pressed a button to request to speak. The 10th is Mr. Brave Chan, Deputy Chair. The 11th, Dr. Junius Ho. And we also have Mr. Paul Tse. And Professor Priscilla Leung. We have about 70 minutes for the meeting today. This meeting will run until 3:30 p.m. So each of you, 4 minutes, questions and answers included. Please manage your time well, and the Secretary may speak succinctly as well. This will allow all members to speak. First member, Ms. Carmen Khan. Thank you, Chairman. We're talking about the follow-up of the Sham kid case. So I'd like to share some of my views. One, this is a judgment or a determination of 3-2. It wasn't passed unanimously. It's also about Article 14 of the Hong Kong Bill of Rights Ordinance. There is room for discussion. There are 2 Chinese judges at the Court of Final Appeal. We have Chief Justice Zhang and Mr. Justice Lam. Article 14 of Hong Kong Bill of Rights, Section 1, it's about protection of privacy. Everyone has the right to the protection of the law against such interference or attacks. This is a passive right. It is not the same as in the European Act, Section 8. And this is in relation to ICCPR Article 17 when it comes to Article 14 on the Hong Kong BOR. Without any legal recognition of same-sex partnerships, it is not a kind of interference. Even in the Court of Europe, there is not an equal sign either. Mr. Judicial talked about differentiating basic rights and core rights. Mr. Judicial had reservations. We are concerned that this system will be turned into a marriage system. Some people think that there are too many core rights, but there are also people holding opposite views. We can see controversy, and there is also a risk of judicial review. Chief Justice Zhang also said having an alternative framework for same-sex partnerships without any flexibility shouldn't be the right way forward in relation to human rights. This shouldn't encroach on the rights of the legislature. Judicial deference principle should be adopted. In the final order of October, the Court of Final Appeal actually didn't agree with Mr. Sham's point of view. At that time, the CFA allowed the government with compelling reasons to apply for an extension. I'd like to ask the government, given significant controversy, will we consult the public, in particular women's associations, religious bodies, organizations protecting minors and teenagers? We should conduct consultation on a massive scale. These should form compelling reasons for the government to apply for extension. In relation to core rights and supplementary rights, there are controversies. So how are we going to deal with these controversies? Secretary. Thank you, Chairman. Thank you, Ms. Kaman Khan. Please go on. Please be brief. Thank you. We respect the judgment of the court as well as its decision. That is, we need to establish an alternative framework for same-sex partnerships within 2 years. The government has been making every endeavor, including conducting detailed research, as well as taking into account the overall interests of Hong Kong. That's how we came up with this proposal. We need to comply with the directions given by the court. Where possible, we will seek to implement the arrangements as soon as possible. This will reduce the impact on persons affected. Chairman, I suggest that we conduct consultation. Thank you. Next member, Mr. Eric Yim. Thank you, Chairman. I have 3 questions. 1. In relation to the registration of same-sex partners, it is not the same as same-sex marriage. Subject to the passage of the registration system, in handling the after-death arrangements, in case there are any differences in the views of the partner of the deceased and the family members of the deceased, who will make the call? In relation to application for public housing, after the death of one of the partners, can the other partner continue to enjoy public housing? Regarding taxation arrangements, will there be further arrangements or regulations? One of the requirements is that the partners must have registered outside Hong Kong when it comes to their partnerships. In case there are financial difficulties, they cannot register overseas or in the mainland. So, upon the passage of the bill of the registration system, will this cause unfairness to those with financial difficulties? These cases may go to the EOC. Will subsidies be provided to those with financial difficulties? There are about 4 questions, Secretary. I will try my best to answer Mr. Yim's questions. Thank you. When it comes to the death certificates, public housing, tax, rights, contract arrangements, I'd like to once again say that the Court of Final Appeal says that we have the positive obligation to establish an alternative framework for same-sex couples, and we need to afford appropriate rights and obligations to same-sex couples. When it comes to contract arrangements, rights and obligations, there is no direction from the CFA. The court wanted to leave it to the legislature as well as the executive in order not to overstep the boundaries. We act in accordance with the directions or the final order of the CFA. So we will afford the rights for same-sex partners to meet basic social requirements. We will consider different factors, including the interests of Hong Kong. We won't cater to the calls or requests of individual members of the public. We consider from a holistic perspective in relation to registration arrangements. In my opening remarks, I already gave a very detailed introduction. We believe there won't be significant difficulties. In considering the verification processes or the verification of a committed and stable relationship, we believe the current method in use is a viable one that won't cause inconvenience. Thank you. In relation to after-death arrangements, it's indeed included under the alternative framework. What if the family members of the deceased requests seek burial, whereas the partner requests otherwise? Well, such a situation may exist nowadays as well. There are conflicting views between family members and the deceased and the partner of the deceased. Usually they can discuss the matter or they can take the case to the court to seek a direction. There's no difference between the existing arrangements and the future arrangements. Mr. Holden Chow, thank you. I'm speaking on behalf of the DAB. We uphold the monogamous and heterosexual marriage system in Hong Kong. Our position has all along been the same. Therefore, I already said that we feel regretful for the judgment of the CFA. We respect people with different sexual orientation. There shouldn't be any discrimination against them either. The registration system this time around, however, rocks the foundation of the marriage system in Hong Kong, as well as the core family values in Hong Kong. We must tread very cautiously. It's not just about homosexual rights, it's about marriage system in Hong Kong as well as family ethics. This time around, the CFA requests the implementation of the alternative framework for same-sex partnerships. A lot of members of the public have already cast doubt on this issue. This registration system is aimed at providing registration for same-sex partners who have registered overseas. The objective result is no different from recognizing same-sex marriage, and it may even lead to issues over the adoption of children. Say there are two fathers or two mothers. Our textbooks will tell children that it's possible to legalize or to register same-sex marriages. So how can we still uphold the monogamous and heterosexual marriage system in Hong Kong? Then our marriage system in Hong Kong will only exist in name. Mr. Justice Sham, Chief Justice of Hong Kong, said that it is not up to the court to decide on the final arrangements of the registration system. We have the responsibility to cherish the monogamous and heterosexual marriage system in Hong Kong. We support this marriage system in Hong Kong. We are against the alternative framework for same-sex partnerships. All right, very clear views from Mr. Holden Chow. Any response? No. Next member, Mr. Stanley Ng.
主席呢，我都
I speak on behalf of the FTU. This is our view in relation to the government's establishment of this so-called alternative framework to handle same-sex relationship. We strongly oppose to it. The essence of a marriage is one of heterosexual marriage. The basic law and our laws are built on this fundamental system. We do not see any same-sex relationship in the legal framework. The recognition of same-sex relationship is, in this matter, involves the court, the government, and society. We have to bear in mind social consensus as well as the long-term interest of Hong Kong. We oppose to this proposal. The judgment shows a flaw in our legal foundation. There are conflicts in the CFA's judgment. On one hand, they decide that they do not recognize same-sex marriage. In the same breath, they require the government to establish an alternative framework for legal recognition of a status that is the same as a heterosexual marriage. On the face of it, it is status quo, but deep down, it completely turns our values and foundation upside down. We don't have consensus in society. There is not sufficient legal justification. This is just a switch of ideas. This will turn our values and social structure upside down. It will cause far-reaching implications. The risk of the legislation will far outweigh the protection it intends. We oppose to this proposal because of risks that we can't ignore. The legislation will afford the parties right. It will also cause systemic changes, and there will be complicated implications. As I said, it has a huge impact on our values. The message sent by the proposal will have a major impact on our morals, our values, and our traditional concept of a family. There has not been any assessment done on these risks. In addition, there is also the financial issues. If we recognize same-sex relationship, there may be an impact on the public finance. We have not done any assessment. It will also cause problems with our system. There is also legal issues. Please be succinct. Let me once again say that the FTU is very determined in opposing to the government's proposal. I'll just give a very short reply. Mr. Stanley Ng and Mr. Holden Chow are respected. But let me remind you that under our legal system, the legal system of the Hong Kong SAR, a decision of the CFA, whether you like it or not, agree with it or not, is part of our judicial system. This is a decision of the CFA. We have to respect it. The legislature and the executive have to fulfill the positive obligation in relation to Article 14 of BORO. This is an obligation we have to fulfill. It's exactly because of this reason that we come up with this proposal to establish a legal framework for legal recognition and to provide for appropriate rights and obligations. We ask you to understand that under the Hong Kong SAR legal system, we must fulfill our positive obligation. You may have different views to the judgment, different views from our proposal, but do understand that we have this positive obligation to fulfill. Mr. Kingsley Wong, we understand the difficulties of the government. We can see it in the paper. In paragraph 6, the government said that it firmly upholds the monogamous and heterosexual marriage system that is stated in the laws of Hong Kong. In paragraph 8, the government says that they will, by way of legislation, make a proposal to enable same-sex couples to apply for registration under the new system for legal recognition. Our marriage system is enshrined in the Basic Law and the laws of Hong Kong. The government wants to put in place a framework to give legal recognition to same-sex relationships or partnerships. There is huge controversy in the CFA's judgment. I see that there is controversy. I have received a lot of comments from different groups, including religious groups. This is a Chinese society, and the proposal will have an impact on our values. Hong Kong is a metropolis. We talk about freedom, inclusiveness. I don't think that being inclusive and respectful is equal to legislating to give this recognition. There can be another way instead of legislation to do what you want. Say, for example, medical-related matters or tax, say, probate. You just use a lawyer. Just confine it to an individual instead of making it a law. Will you consider other ways? Say, for example, I give the power of attorney to someone else to handle my death-related arrangements. This will cause much less a controversy. Secretary, I fully understand Mr. Wong's point. The establishment of an alternative framework, must it be by legislation? Can it be done by administrative means? That's the point of the member's question. Let me say this. It has to be done by legislation. I'll defer to the DOJ for a further explanation. Mr. Luenimui, Solicitor General. Perhaps I will supplement some information from the legal perspective. The CFA has made a judgment, a majority decision. The decision is that failure to establish an alternative framework does not meet the requirements under Article 14 of BORO. The requirement is that the government needs to fulfill a positive obligation. We're aware of the different views. But as the Secretary said a number of times, we're a responsible government. We have to follow the judgment of the CFA, albeit a majority decision. There are details in the judgment explaining what a legal recognition framework is. In short, it will be a legal framework of recognition, giving the recognition an official one. Once the partnership is registered, a legal status recognized by the law will be given. This is a protection of the status. It is a recognition on a legal and official level. It's different from the protection mentioned by the member. We'll see if we have another chance for further discussion in this regard. Dr. Teck Chi Yun. The government said on a number of times that their proposal is based pursuant to the judgment of the CFA. We represent the people. Now there is a judgment, a court judgment that you have to act on. But how do you balance the mainstream view of society? You are required to follow the judgment of the court. But what about public sentiment and public views? My second question is that now the government comes to us with a proposal pursuant to the CFA judgment. If the LegCo opposes to it, then what will happen to the CFA judgment? The effect of our objection is that the LegCo does not accept the court's judgment. What will the government do? They will respect the decision of the court or accept the decision of the LegCo. And 3, with so much controversy in place, will there be a detailed plan in place?
好，多謝。
3 questions. Secretary, thank you, Dr. Teck, for your questions. Dr. Teck asked, what if the public sentiments or views are different from the court judgment, what will happen? Well, the judgment of the CFA has already taken into account the overall situation in Hong Kong. From the perspective of legal provisions, there will be interpretation. There will also be case laws. But of course, I believe the courts will not disregard the actual situation in Hong Kong when handing down its judgment. Well, do you mean the court has already taken into account public sentiments when handing down this judgment? Well, I believe the court must have considered the situation in Hong Kong as well as public sentiment while handing down its judgment. People's views may vary, but this is the judicial system in Hong Kong. We need to have faith in it. The system has already considered the public views and public sentiments in Hong Kong in its decision on the contentious matters in Hong Kong. Well, I have reservations about this. Secretary, you may move on to other questions as well. Well, we respect the decision of the court and we will act in accordance with the final order. Well, what if the Legislative Council opposes the registration system? What will happen? We do our best to explain the registration system to council and we strive to persuade members. Well, I'd like to ask a point of law. Let the secretary finish first. At this stage, we do our very best to fulfill the positive obligation to carry out our work. I hope the legislature and the executive will work together to implement the final order of the court. Well, if the bill isn't passed by the council, what will happen? I will ask the DOJ to give you a more detailed reply. Mr. Mui, thank you. I will respond to Dr. Tek's questions briefly. First of all, the judgment handed down by the CFA is that the government does not have an alternative framework for same-sex partnerships and that cannot fulfill the positive obligation requirements under the Hong Kong Bill of Rights Article 14. The government is making every endeavor to float this proposal after much effort. In the judgment of the CFA, it is set out very clearly and cautiously that the role of the court is to interpret law, as well as provisions under the Hong Kong Bill of Rights Ordinance. It doesn't have to do with interpreting the basic law. The CFA fully understands for the registration system to be legalized, the government will have to take the initiative and it will have to be approved by the Legislative Council. The court understands the division of work very well. Assuming that this bill is not approved by the council or is not passed by the council, the judgment handed down by the CFA still remains valid. Whether the government has fulfilled this positive obligation or not, the judgment of the court remains valid. The court cannot set up an alternative framework on behalf of the government. In this case, the government still has the responsibility to do so. We do think the government remains to have this responsibility. But of course, we look forward to a better method to handle this matter. Dr. Tek, in the interest of time, if you would like to follow up, please press the button again. Next member, Ms. Maggie Chan. Thank you. I uphold the monogamous and heterosexual marriage system in Hong Kong as well as the traditional family values. I strongly oppose the proposal submitted recklessly by the government. It neglects procedural justice. Calls in the community have fallen on deaf ears. I oppose it because of one, the judiciary or the Court of Hong Kong allows the administration to apply for an extension. There's a lack of consensus in Hong Kong. This is a major obstacle. In the judgment on the CFA, it says out very clearly that the government has discretion when it comes to setting up an alternative framework. If there is strong opposition, the government can apply for an extension. In society nowadays, we haven't yet started discussion. So how can we say that the discussion is mature? There are indeed obstacles, and the government should apply for extension, taking into account the overall interests of Hong Kong. A traditional family system is the cornerstone of the stability of Hong Kong. It's about cultural identity as well. The public hasn't been consulted, and this will weaken the traditional Chinese marriage system, family values, and so on. This will also potentially affect social harmony as well as family harmony. I'd like to point out in relation to positive obligation, we shouldn't just read the judgment of the CFA, we need to read the basic law as well. We have one country, two systems. We are based on the principle of executive-led. It is the government that makes policies. Mr. Justice Lam emphasized in the judgment that the alternative framework is about social policies. It should be determined by way of political procedures. Just now, the Secretary or the DOJ said that the court had already taken into account the overall interests of Hong Kong. Like Dr. Tick, I strongly oppose this. We don't agree. Mr. Justice Lam said in particular, as for the necessary rights arising from legalizing same-sex marriages, there is no sufficient and mature discussion and consensus. In other words, we have the legal responsibility and the constitutional responsibility to make a political decision. Well, I respect the judgment of the CFA, but we do need to read very carefully the contents of the judgment. The judgment is about the adjudication of the facts of that case in question. We have one country, two systems. This is the principle we abide by. From the perspective of the government, the political procedures haven't yet been completed. That's exactly why the administration should consult the public first. There's a lack of consensus in the public, in society. The public hasn't been consulted. Are you going to apply for extension? Are you going to conduct consultation to listen to the views of the public? We need to uphold our traditional marriage system in Hong Kong. It's monogamous and heterosexual. This is the system we have in Hong Kong. Well, you have used up all your time. Secretary, please be brief. Well, It's difficult to give a short response. There are so many questions. Well, in brief, regarding an extension, we have no intention at present. We still want to complete the relevant procedures within the time frame required by the court. We will do whatever it is required of us to complete all the procedures regarding upholding the monogamous and heterosexual marriage system in Hong Kong. It has always been our position. We have never wavered in this regard. According to the judgment of the CFA, Article 14 of the Hong Kong BOR says very clearly that no one shall be subjected to interference with his or her privacy, and this is protected by law. We work with the legislature to make laws to protect members of the public. So if we fail to fulfill the positive obligation, it's not just the government, but the executive as well as the legislature. So I do think we should respect the judgment of the court. With this in mind, we do have a positive obligation to set up an alternative framework. Dr. Starry Lee, Mr. Holden Chow already spoke on behalf of the DAB that we uphold the monogamous and heterosexual marriage system in Hong Kong. In society, because of different reasons, we understand adults have different sexual orientation. We shouldn't discriminate against them. However, if we choose to provide for registration by way of legislation, I don't agree. As many members have said, we need to respect the judgment of the court, but as a responsible government, before legislation, the administration should make full assessments of the possible impacts on different quarters of society. In the document, there is no mention of the assessments. Have you conducted any assessment? If yes, can you share with us? If not, are you going to conduct any assessment? When are you going to submit the bill or table the bill to the council? We understand the legislative processes should be very cautious. It affects the values of society as well. This will affect values of young people as well. Otherwise, young people in Hong Kong may receive the wrong message that same-sex partnerships would be legalized or recognized in Hong Kong. This registration system will be no different from recognizing same-sex marriages. In the US, for instance, similar situations have already happened. Are we going to move towards this direction? The US is actually calling a halt on this. The president of the US, who has just taken office, already said that there are just men and women. If the administration has conducted assessments, can you share with us? If not, are you going to do so? Otherwise, you shouldn't introduce the bill to the council hastily. It is difficult to accept that we need to discuss legislation without any consultation or discussion. Thank you.
I thank Ms. Lee for her questions and comments. We have conducted an assessment. After the CFA has delivered the judgment, the government has done a lot of work. The work includes conducting an in-depth research on the spirit of the judgment as well as the requirements. We also conducted research on how we can fulfill our positive obligation. That involved a lot of researches. While we have to fulfill the requirements under the CFA's judgment, we have to, at the same time, consider the impact on society. We have to conduct assessments on different aspects. It's because we have conducted a series of assessments. That's why we have come up with this proposed mechanism covering conditions, rights, and obligations. We have taken into consideration the requirements of the judgment and Hong Kong's situation. If you talk about consensus in society before we start our work, it will be very difficult to start, and I don't know when we will even take the first step. Don't forget that the court has clearly stated that we have not fulfilled our positive obligation under Article 14 of the BORO. We have to plug the gap. We need to fulfill the positive obligation. We have conducted assessment before we come up with a proposal. Ms. Lee, I think that the assessment will have to be more extensive given the fact that the proposal has far-reaching implications on our society. I asked the Secretary not to introduce the bill yet. Mr. Lee Cheng-kang. The Liberal Party has been opposing to legalizing same-sex relationship. We uphold traditional family values. We have received comments from various organizations and bodies, family organizations and religious bodies, expressing their concern that they think that this is a step towards recognizing same-sex relationship. Now there is this proposal to establish the same-sex relationship registry. Do you expect the same-sex partners to come in their wedding gowns? Do you expect them to post the pictures on socials? What about textbooks? Do we need to change the contents of our textbooks? We have conducted some surveys. Over 80% of the respondents were concerned that if the message was sent, then young children might have a misunderstanding of marriage and families. Well, the survey was done a long time ago. And the young children might be affected and thought that it is okay to be in a same-sex relationship. My next question is in relation to the registration. If the law is passed, and what if the place where the marriage was registered all of a sudden said that the registration became invalid? Is it the case that the couple will have to go to a different place to have a registration before you give them the recognition? Do the parties have to go to a marriage registry in these other places? Do they have to use a lawyer? So are these the things that they need to do before they meet the conditions? Secretary, I thank the member for the question. Mr. Lee is very concerned that if we give recognition of same-sex partnership, in the future we will recognize same-sex marriages, that this will undermine our traditional family values. There is unanimous decision by the court that the legal recognition of same-sex partnership is not equal to a recognition of same-sex marriage. The constitutional freedom of marriage guarantee is heterosexual marriage. We don't have any plans to change this concept. I ask members to rest assured. In relation to overseas registration, the member came up with some specific examples. Say, for example, there was a registration, but it was later deemed invalid. That depends on the situation. Perhaps when the registration was made in the first place, there were misconducts found, so the registration was revoked, or there was a change, or there is a change of law. I can't give you an exhaustive list of the different scenarios. What we say is that it is registration that is done in accordance with the law and is deemed valid. Next, Deputy Chair, Mr. Brave Chan. Thank you. The two Chinese justices agree that even without the legislation, it will not be deemed as unlawful interference. We all agree that we need to avoid having any impact on marriage system and traditional social values. No matter how you do it, as Mr. Holden Chow and Ms. Starry Lee said, that you can't avoid having an impact. Now you propose an alternative framework. It is, in one way or another, an impact on the original system. You may say that this doesn't equal to a recognition of a marital relationship, but still you have taken a step. People may think that now you have taken the first step, you will continue. That is the point that is of concern to a lot of different parties. But the gate has opened by the first step. Everything starts with the first step. When it comes to upholding the traditional marriage system and values of Hong Kong, what is the best way to tackle it, to handle it? Mr. Chen says that, well, today we take the first step, and tomorrow or in the future we will continue. I'm not going to make any predictions. We only look at the issue we face now. The issue is that the court has delivered their judgment. This is the court of final appeal. Their decision is that the government has not fulfilled the positive obligation under Article 14 of BORO to ensure that no one will be subjected to unlawful interference with his privacy. We will put in place a framework to give them legal recognition so that they will not be subjected to unlawful interference with his privacy. There is a legislative system, there is the executive system, and they are all the fundamental systems of Hong Kong, the Hong Kong SAR. If we do not support or uphold the judgment of the court, how can we continue to manage the affairs of Hong Kong? We are the executive. We respect the judgment of the court. This, even if we have different views, we respect that this is one of the important pillars of the Hong Kong SAR, that is the judicial system. We respect the legal system in Hong Kong and the judgment of the courts. I ask you all to support us in our fulfillment of the positive obligation. Of course, if there are areas where you think we need to improve on, then we will do so. But I ask you to help us to fulfill our positive obligation. Mr. Junius Ho. In the past year and a half, Secretary, what have you actually done? You said you've conducted a lot of studies, assessments. This is just hot air. What have you actually done apart from going through the motions and showing us that you don't know the law? You have not done anything in the past year and a half. Just like other members said, you should have sounded out the public. If you could not make a decision, then conduct a survey. This is near the end of the 7th term of the Legislative Council. You just want to rush it through. It is ugly. If we unanimously oppose to your proposal, a proposal that is put together in a rush, Mr. Mui said that even if that is the case, we still have the duty, the obligation to do that. Do you think the CFA is always right? Back in 1999, the Nkaling case, well, we have about 1.67 million people that would come to Hong Kong as a result of the judgment. It was down to people who have a sense of responsibility, who sought an interpretation of the basic law. Yes, the CFA may have the power of final adjudication, but that doesn't apply to our national defense or diplomatic affairs. If the court can't handle something, then we will go to ask for interpretation of the basic law. Have you considered that in the past year and a half? If so, why did you decide not to go for an interpretation? Well, I said that, you only have to go to the NPCSC to have it resolved. So the court doesn't actually have a final adjudication. The decision can still be superseded. Just find someone, maybe me, maybe Mr. Holden Chow, to introduce a private member's bill to overturn the decision of the CFA. The CFA talks about positive obligation. Is there a negative obligation? It's just terms that the public will not understand. I think that you are not positive at all. You're doing something that is quite negative. Yes, a private member's bill will have to give way to the government if they are going to take action. But it can still go ahead. If there is no implication on public finance, then we can move a private member's bill. We are part of your team. You have refused our help. Can I have more time? Your time's up. Well, let me finish, please. It's not the first time when we told you. We have been asking you to do it, because it has far-reaching implications. The implications will reach our posterity. I think the core issue is the protection of family, children, mothers. Not just women, but mothers. Well, under the national security law, we have to guard against undesirable impact. And in the basic law, it says that we have to ensure that there is a monogamous and heterosexual marriage system. It's not explicit like that. Whereas we know that when it comes to protection, it's not unfettered. The legislature, the judiciary, as well as the executive will all have a duty to guard against any ideas that may undermine the national security. It is simply wrong. I think your time is up, Mr. Judicial.
Chairman, allow me to respond in brief. I'll put it briefly. Dr. Ho used a lot of pointed adjectives. There are a lot of pointed remarks. Simply put, this is not a rash decision. At the end of the day, we will have to come to the Council within the 2-year period. Now, we consult the Legislative Council. We are going through the procedures. So I don't think this is a rash decision. In the past year and a half, unlike what Dr. Judicial said, we have done our part. We have studied the spirit, the contents of the judgment of the CFA. We have taken a holistic view, a holistic look of the overall situation of Hong Kong. We have worked with legal experts, the relevant bureaus and departments as well. We have put our heads together. So I'd like to say that this is not a rash decision. We are working with the legislature to complete the requirement given by the court. This is a court judgment. It has nothing to do with the interpretation of the basic law. Thank you. Next member, Mr. Paul Tay. Chairman, to a certain degree, I'm glad to see this debate. All of us will do our best to debate on this topic. Just now, Dr. Tech asked, what if the Council is opposed to this bill? Then probably there will be judicial reviews. We will probably wait until the CFA gives us a judgment that is to our liking. The judgment of the CFA is a final adjudication, not just a majority decision. We need to take into account the Court of First Instance, the Court of Appeal as well. It was a decision of a majority 7-2. I'm a victim, so to speak, of the Court of Final Appeal as well. I had different cases at the CFA. We may not like the decision of the CFA, but we still have to respect the decision of the CFA. If we disregard the judgments or decisions of the CFA, well, I have reservations about this. This alternative framework is somewhat conservative. We don't even have a primary registration system. It's a secondary one. In other words, when someone has already registered outside of Hong Kong, then they come back to Hong Kong to apply for registration once again. This is a secondary registration system. The level of protection is quite limited. There is no protection mechanism for same-sex couples in relation to inheritance. We need to safeguard their interests, and the administration is just protecting same-sex couples in relation to their core rights, say medical-related matters, identification of bodies, and so on. In my opinion, this framework is quite conservative. It's not a full step. We can call it half a step. We need to work within the framework of the rule of law. We are living in a civilized society. We need to view different issues from the perspective of humanity. If this council is opposed to this bill, what if we don't support the government? The end result is that there will be people applying for judicial reviews back and forth. There will be a lot of such judicial reviews in legal proceedings. Is this what Hong Kong wants to see? Is this what the public want to see? All of us I am against homosexual marriage as well. But we are in a catch-22. How can we move forward? We need to respect humanity. We need to respect civilization as well. We need to strike a balance. But I'm afraid there's a lack of this view in the council. The administration has taken quite a bold step. We are nearing the end of the current term of the Legislative Council. But I do look forward to a fairer and a more balanced way forward. Secretary, thank you, Mr. Porte. I have nothing else to add. Thank you, member. Next member, Professor Priscilla Leung. Well, I think this is a wrong step on the part of the administration. This proposal is no different from opening a Pandora's box. There will only be a lot of legal proceedings, and this is not unique to Hong Kong. It's the same in other jurisdictions. The government will just end up spending more on this issue. This is same-sex partnership registration ordinance. But I started to study the marriage systems in different jurisdictions starting from 1992. If you aren't same-sex couples, then you will have to register your marriage under the marriage ordinance. It's all about rights afforded to couples as a result of marriage or by virtue of marriage. Well, I don't think we will have reached results if we are going to carry forward this issue this way. My predictions are accurate, and this is my advice for the administration. If you have to take this step forward, well, I have no way to stop you. It is your decision. When it comes to Constitution, Chairman said that this has nothing to do with the Basic Law. As I remember, in 2019, when the members back then asked for 35 plus, they said that it wasn't against or it wasn't at odds with the Basic Law. And I was the first member to come forward to say that it clearly violated the Basic Law. Our discussion today is about the ordinance or legislation in Hong Kong. Basic law is a national law. Then we have the Hong Kong Bill of Rights, which is about a district. You talk about ICCPR, Article 19 of the International Covenant on Civil and Political Rights when it comes to freedom of expression, morality, and sanitary are exceptions. Regarding Article 18, brackets 4, we talk about parents as well. Upon this deciding on the ICCPR, there were exemptions because different aspects need to be respected as well. We aren't just talking about 8 million population in Hong Kong as well as our posterity. It's about the ordinance we are talking about. I often promote ordinances in Hong Kong to the world. I train mainland judges. Law students in the first lesson understand what advocacy means. You are saying that you aren't doing this, but then you are actually promoting this. The US, the UK, they're victims and they want to go back. The W case told us that Legislative Council had the power to negative any proposal. There should be discretion. It's about important social values. It started by the administration, not by the council. So Chief Justice of the CFA knows this very well. The council has the right to negative the bill. The result will just be the same. There will be a lot of legal proceedings. It won't end until a brave member comes forward to formulate or to introduce a private member's bill. We need to uphold the monogamous and heterosexual marriage system in Hong Kong. I respect sexual minorities, but we in Hong Kong see extramarital affairs as well. It doesn't mean that we need to change our marriage system in Hong Kong. We respect sexual minorities. We respect their rights. However, it doesn't mean that we need to cause confusion in society, especially young people. Well, my last sentence, the administration should think twice. When there are compelling reasons, political parties won't support what you're doing. You need to conduct consultation. You didn't conduct any consultation, but then you are submitting this paper to us. You are just talking about the big direction for Hong Kong, not the details. Well, I believe Professor Leung has made her point very clear. Well, in the interest of time, I will first of all extend the meeting today by 15 minutes. After Ms. Doreen Kong asks and the administration responds, I will let 4 members in the second round speak, each 1 minute. Then I will ask the Secretary to respond, to give a consolidated response. All right, Secretary.
Do you have anything to add? I don't have anything in particular to say in response to what Professor Leung has said. I won't comment on them. The name itself, that is Registration of Same-Sex Partnerships Bill, shows the essence of our work. I don't understand how she sees that name as an equivalent of same-sex marriage, or that it in the future will become same-sex marriage. We have never, the administration nor the court, have any intention to recognize same-sex marriage. I think I have abundantly stressed on this. Ms. Doreen Kong. This is an issue about rights enshrined in the Constitution. Members have been very cautious. We need to fully understand and consult the public. I heard the Secretary said that at this stage, there is no plan to ask for an extension from the court. When I found out that there is this discussion today, I had the impression that this is done in a rush to meet the deadline. I felt that time was tight, and we were forced to make a decision. A lot of members have said that we'll need more time to conduct consultation and collect public views. Shouldn't the administration apply to the court in advance for an extension so that there will be sufficient time for the LegCo and the public to consider? Well, there are several points under the proposal: registration for the relationship, medical matters, death arrangements. We have to consider the proportionality test. In relation to these three areas, three categories, have you conducted the proportionality test before you come up with the three categories of rights and obligations? In the paper, there is mention about rights of same-sex relationships. When you talk about that, what about heterosexual partnership? People in a heterosexual relationship may want the same rights. Have you considered that? I thank the member for her questions. We have collected members' views. And as to whether we will consider asking for an extension from the court, as I said, under our plan, we do not intend to ask for an extension. We want to take action to fulfill our obligations within the time frame set down. We have heard members' views. We will mull over these comments as to whether we will make a different decision after this. I won't be able to give you an answer now. What I can say is that we have heard members' views and we will carefully consider them. In relation to heterosexual relationship, well, this is an alternative framework. We do not recognize a marriage. So we have to give them a way for the relationship to be recognized. People in a heterosexual marriage may choose not to get married. In relation to proportionality test, the proportionality test. In terms of the conditions, the categories of rights and obligations, we have considered different factors, views from the public, policy considerations. We have considered them all. There's always the view of whether it's too much, not enough, or too much or not enough. I think that is my reply to the point about proportionality test. 5 members have pressed the button to speak for the second time. As I said, each member will have 1 minute. I then will ask the secretary to give us an overall reply. Ms. Carmen Khan. I heard a common appeal from members. We think that we need a full consultation. The Secretary talks about the duty of the legislation to fulfill the positive obligation under Article 14 of the BORO. I hope that, Secretary, you will hear us loud and clear that we ask for a consultation before legislation. If there is a strong view, if there is robust justification, then you can apply to the court for an extension. The 3 powers will do our respective duty. Can we have a resolution? Can we move a resolution requiring the government to conduct public consultation before they move ahead? Sorry, we can't do that today. Next, Mr. Junius Ho. If it can't be done today, when? We always have different motions. Motion for an adjournment or many other different motions. Don't force my hand. This is a kind of warning to you. We've always been asking for consultation, and it was done. The electoral system has been improved. How come we are emasculated? We ask for a public hearing. You now say that it can't be done? I think there is a chance for us to handle this in the future. We have to act in accordance with the rules of procedure. Well, I have the rules of procedure here with me. Paragraph 3.45 says that the time of notification should not be less than 2 whole days. I would like to say that back in 2004, when Leung Kwok Hong joined the Legislative Council, I said that there would be an interpretation of the Basic Law, and it happened. In 1995, I said that there would be a lot of judicial reviews in relation to the right of a bull, and it would also lead to the Basic Law interpretation. In the end, it happened. I'm telling you that this is not just about Article 14 of the BORO. It also involves the relationship between the Basic Law as well as the BORO. The Basic Law is above the BORO. The executive, the legislature, and the judiciary. Has any of them crossed the line? I have already said in the previous case that the judiciary or the court should not take over the duties and the powers of the executive or the legislature. So under Article 10B of the judgment, I say that the government has a right to apply for an extension. If you charge ahead, you will suffer defeat. Well, we saw that there were about 10,000 people in an assembly in the W case when there was they were people who were who think, well, they were people who thought that it would harm family values. I don't think you'll be able to control the situation in this regard. Mr. Porter, Professor Leung is an expert. Well, in the basic law, it's clearly stated that an article specified the clear delineation of areas where there can be interpretation. Well, I would not be like what Professor Leung said, that there would definitely be the interpretation of the basic law. It is an awkward time. It's near the end of the legislative term. Would the administration consider the pros and cons of applying for an extension? Maybe they can tell us about the difficulties they face so that we can give them our views. Now we will hear the concluding remark of the Secretary. I thank members for their comments. We have heard different views. It shows that the legislature has played its role. We have heard a lot of valuable views. There are only a few things that I'd like to say. A lot of members are very concerned. They are very concerned that this will end up in the recognition of same-sex marriage. Let me once again say this. The court and the government have made it crystal clear that under the basic law, a marriage system is one of monogamous and heterosexual one. The government has no plan to make any changes to this. I have heard members' views. The views about a possible extension. Mr. Porter talked about compelling reasons and what reasons we have. We will follow the directions of the court as far as are practicable to meet the requirements. It's not the case that we can't have an extension, but is this a compelling reason? We will go back to look into it. We came here because we did not have the plan to ask for an extension. This is the positive obligation of ours. We will do our best to make improvements so that we will get your support. It's something that we will do. Under the judgment of the CFA, we both have the positive obligation to meet the requirements of Article 14 under BORO. We have spent a lot of time and done a lot of work on researches and studies before we come up with this proposal. We have consulted members on this occasion. We will consider the views before we decide what to do in the next stage.
We've had a fruitful discussion. Members have put forward their views. That's why I allow some members to speak beyond the time limit. I also allowed the Secretary to give you a response. I believe the Secretary will take into account the views expressed by members. Some members have pressed the button to request to speak again, but owing to the interest of time, this is the end of our discussion today. Any other business? No, meeting adjourned. Thank you.